In terms of a basic introduction, the case which was just handed down in the Court of Appeal on the 1st of April, Adams and Options, formerly Carey, is a test case. It was a test case which went horribly wrong at first instance for a number of reasons. It was heard before His Honour Judge Dite CBE over 5 whole days, and it took him about 26 months to produce his judgment. From my research, having been tasked with one of the grounds of appeal, the delay ground, it appears to be the most delayed judgment in any reported decision in UK legal history. So that's a very bad starting point. The Financial Conduct Authority intervened at first instance and on appeal, which underscores the importance of the case. The case itself is for relatively modest damages. It was defended very strongly by 2 silks from leading chambers, which gives you an understanding of how important this case was despite its modest damage value, because there are a number of other cases which will be affected by the outcome of this case. As a result of the delays of the first instance judgment, a number of cases have been stayed for significant periods of time. There are a number of false complaints which have been delayed or stayed. There were 3 claims that were pursued at first instance: the statutory claim, the Cobbs claim, and the joint tortfeasorship claim. All 3 claims were rejected. The first instance judgment, and of course, we would say that because John Virgo, who I'm speaking with, was involved as co-counsel, but leading counsel at first instance. I was involved as junior counsel on appeal, but the first instance judgment is extremely poorly reasoned. The statutory claim and the Cobbs claim were renewed on appeal. The appeal was allowed on the statutory claim. The Cobbs claim or the Cobbs appeal was rejected, dismissed. There were a number of significant implications which arise out of the Court of Appeal's decision, and we'll consider some of those implications in this webinar. In terms of a brief outline and structure for the talk, John Virgo is going to take us through a whistle-stop tour, necessarily, I should say, of the history of products in the area of pensions. I will then deal with the promotion of SIPPs and the problem of unregulated introducers. That's the statutory claim. John will then deal with the Cobbs claim, and then we'll both split defenses. I'll consider the statutory defense under Section 28 of FSMA, and John will consider the efficacy of contractual defenses, which were run at first instance and on appeal. And then finally, I'll close with some concluding remarks.
Well, good morning. I hope there's some feedback on my end. I hope that's not afflicting the hearers. Thank you, Jay, for that introduction. As Jay has foreshadowed, the first section of this talk is going to look at the history of pension provision in this country, just in thumbnail outline. And the reason for doing that is in part, I hope, that it is of interest, but also to put into context the way in which SIPP products have come onto the market. And one can see, I think, in the history of the provision of pensions in this country, if not the genesis of the problem, at least the opportunity for mis-selling of this particular type of product to have arisen. Pensions do indeed have a long history in this country, going back to medieval times. There are some early examples of royal pensions being awarded, for example, for loyal service to the crown in the first instance. And as one moves forward in time, that became the model in the 17th and 18th century for certain types of occupational pensions to be provided for government employees. And some examples are given there on the slide, and it showed a particular sensitivity towards serving naval officers. By 1810, there was an established civil service scheme providing benefits pretty much across that service. And then by the tail end of the 19th century, other public sector employees had been granted pensions modelled on that civil service scheme. So an example of that is the provision of pensions for the police force from about 1890 onwards. There was then a uniform pension scheme for local government staff established by 1922. But it was the 20th century that saw a significant expansion in the provision of pension, both by the state, and now one sees companies also making provision for their employees. It begins with the state pension, as we now know it, introduced as long ago as 1908, and then larger companies, and no doubt people will recognise the largely of a philanthropic disposition, Cadbury's and Rowntree's, and the like, offering pensions for their long-serving employees. The focus of those schemes in terms of employer was very much in terms of employer provision. That left out of account obviously self-employed individuals and those who weren't able to access an employer-sponsored scheme. And that was dealt with from about the mid-1950s onwards by the introduction of the retirement annuity contracts. Those were introduced by the Finance Act in 1956 and later came to be governed by Section 226 of ICTA. I suspect the more grey-haired among us will be well familiar with the so-called 226 policies. On the whole, the public sector and company-sponsored schemes, however, operated by providing defined benefits linked to a retiring employee's length of service. They often included indexed increases of the pension both before and after retirement, and benefited obviously from contributions made by the employer. And the essential feature of all of those schemes was, as one can see from that history, that it was the employer or the pension provider that carried the risk of the product. It was in the 1980s, and in particular under the Conservative government, that with the emphasis on privatisation, that brought the first very significant change to the UK pension landscape by replacing retirement annuity contracts, 226 contracts, with the new form of personal pension policies, which became available from the 1st of July 1988. At one level, both personal pension plans and retirement annuity contracts operated in a similar manner, in that they allowed the pensioner to contribute to a fund to build up a lump sum, which could then be used at retirement to provide a tax-free benefit, and the balance of the fund then had to be deployed in the purchase of an annuity taken at the latest by age 75. The important feature, and this is where one sees the expansion of risk and the gradual shifting of risk, product risk from employer/provider onto the shoulders of the pensioner, came about in this way, that the new styled personal pension plans were able to accept transfers out from defined occupational pension schemes. Point one. Point two was that they obviously allowed the pensioner to make contributions into the personal pension plan themselves. Before that change, the only way to move funds out of the occupational pension scheme was to transfer it into what, again, the more grey-haired among us will recognise as Section 32 buyout policies, or Section 32 buyout bonds. Those were introduced by the Finance Act in 1981. And it wasn't until April 2006 that it was possible to add contributions to that type of policy. Now, it's in that historic context that self-invested pension plans were introduced by the Finance Act in 1989 as a formal variant of personal pension plan. And I think that the key is obviously in the title to them, because they allowed the plan owner to direct how the contributions were to be invested. That was subject in the early instances to some restrictions on investments which were not permitted to be held within that type of wrapper, which was set out in the Permitted Investment Regulations of 2001. Those were essentially done away with by the Finance Act in 2004, so that a SIPP wrapper can now pretty much hold anything, with the proviso that certain types of investment, and the notable and obvious example is residential property, if held, will attract an unauthorised payment tax penalty. The history, as I say, therefore reflects an ever-increasing shift of risk from employer pension provider to pensioner. And many of us will recall that the first explosion of claims resulting from that type of pension liberation during the pension review era of 1988 to 1994, some 8 million odd people invested in personal pension plans during that 6-year window, and it is estimated up to 2 million of those individuals suffered losses as a result of poor pension advice. You'll recall that there were 3 categories of affected individuals: those who were persuaded wrongly to transfer out of defined benefit schemes, losing the protection and benefits that those schemes offered. There were those who were persuaded to opt out of such schemes as regards future service, so-called opt-out cases, and individuals who were eligible to join occupational schemes but were persuaded wrongly to not to join, the so-called category of non-joiners. And that episode cost the industry an estimated figure just under £12 billion to sort out. Despite the experience of the risks that were created by that form of pension liberation, there was a continued expansion of allowing individuals to be exposed to risk by the Finance Act 1995, which introduced pension fund withdrawals, or so-called income drawdown plans. That was, in a sense, a response, I think, to economic pressures at the time, because annuity rates were low and therefore rendering those products unattractive. And the apparent attraction, or the allure, of an income drawdown plan was that the pensioner could withdraw money directly from the fund within, in terms of monthly or annual increments, within parameters set by the government actuaries department, which were then varied at 3-year intervals. And again, I'm sure many of us operating in this field will have been involved in cases concerning the mis-sale of income drawdown plans of that kind. From the 6th of April then 2007, the activity of establishing, operating and winding up personal pension plans, and therefore SIPPs as well, became regulated by the Financial Services Now Conduct Authority. And I note that in a consultation paper a year before those activities were brought within the subject of regulatory control, the regulator published a paper expressing the intention that there should nonetheless be consistency for consumers across all pension schemes, so that consumers have or are given suitable advice from across the whole range of products. Now, that was no doubt an extremely laudable objective. One has to say that in practice, the extent to which it has been delivered has achieved somewhat mixed results. And before I hand back to Jay, I'll just bring matters fully up to date in terms of this historic transition of risk from provider to pensioner, which one can see in the Taxation of Pensions Act 2014, which from the 6th of April 2015 has allowed pretty much unrestricted access to pension funds. And I've given you some data there on the slide illustrating the uptake that product entailed or has seen. And insofar as SIPP products suffer from the risk that unscrupulous advisors encourage people to vest or use those funds to access esoteric and expected high-earning return products, which turn out to be rather illusory. Of course, exactly the same risk is inevitably inherent in the new form of access to pension funds. So one can see an overlap and then the potential, again, I'm sure, for an explosion of claims as a result of that entitlement. So with that historic review and setting SIPPs in context, I'll pass back to Hugh.
Or Jay.
Or Jay.
I'm just going to take us through a brief tour of the outline facts in Adams, because the Adams case is not unique. There are a number of other cases that are very similar. It's an exemplar of the problems that are associated with dealing with regulated entities like Carey stroke options, which I'll refer to as Carey in this webinar, dealing with unregulated introducers, because there were a number of aggravating features and a number of risks which were undertaken as a result of those business dealings. So there's four main players here. There's the client, Mr. Adams. There's Carey, C. There's CLP, which is the unregulated introducer. And there's Store First. Now, Store First is the investment company that sold the store pods in Blackburn. And if there's ever an esoteric investment to put a modest pension into, it would be store pods in Blackburn. So Mr. Adams is a goods vehicle driver, and he had a modest personal pension plan with Friends Life, a well-known provider, valued at just over £50,000. He was in desperate need of money, and he saw an online advertisement which said, "Release some cash from your pension." Now, releasing cash from your pension is a no-no for obvious reasons, because it will attract a tax charge, which is exactly what happened once the revenue realized what had happened with Mr. Adams. That advertisement led to CLP's website. CLP was based in Spain and was unregulated. One of the arguments that we were trying to push, although we didn't get too much traction in the Court of Appeal, is that it was offshore. And Lady Justice Rose seemed to take issue with the fact that we kept on referring to it being an offshore entity, because apparently there's nothing wrong with an offshore entity based in Spain involving themselves in investment business in the UK. Mr. Terence Wright was a joint controller of CLP. Now, Mr. Wright is significant because in 2010, so before the material events that took place in this case, the FCA or FSA at that time had published an alert concerning him. Now, Carey didn't appreciate that until sometime later, as I set out the chronology, but the point of the alert is that the FSA was warning regulated entities not to deal with Mr. Wright, because Mr. Wright was likely to have been involving himself in regulated activities without authorization. So in terms of the relationship between Carey and CLP, that started in about August 2011. There were terms of business, so there was a contract that was entered into between them. It was structured in such a way as to support Carey's business model. Carey's business model is execution only, which effectively means not really doing much at all. But there was that contract itself was littered with boilerplate that CLP undertook not to provide advice, not to carry out regulated activities. At the start of the relationship, CLP had confirmed that it was typically receiving commission on introductions that it affected of between 2% and 5%. Now that's significant for reasons I'll come to. Low commission is generally okay. High commission is a red flag for obvious reasons. In terms of Mr. Adams, as I said, he saw an advertisement. He followed that advertisement. It took him to a CLP website. That took place in about February 2012. As a consequence of CLP's activities, now that was contentious because the other side took issue with that, but let's just leave it relatively neutral. Mr. Adams decides to transfer his PPP, decides to establish a SIPP with Carey. to receive the funds from that transfer, and he decides to use those funds to acquire store pods in Blackburn, which were meant to be held SIPP. I've emphasized a number of events on this slide because they're red flags or warning signs or alarm bells. It doesn't really matter how you describe them. Now, in May 2012, and the chronology is important. So the SIPP had been established in this case at this time. The monies hadn't been transferred yet from the PPP, and the store pod investment hadn't been executed at this time. Now, Carey finds out that CLP is actually receiving substantially higher commission of a magnitude of some 12%. Now, that's a very big red flag, because the obvious question is why and where is it getting that from? There are a few other red flags in May 2012. Now, Carey discovers that CLP was paying inducements to investors, and it then terminated its relationship with CLP. Now, inducements, as I said, attract a tax charge, but where is the money coming from the inducements? And there's an obvious link or nexus between the high commission and the inducements. It also, as a result of those alarm bells, goes on and does a bit of research. It discovers the earlier FSA warning notice about Terence Wright. In terms of completing the chronology, because it's important, it had all that knowledge at that time. In June 2012, the PPP transfer into the SIPP takes place. In or about mid-June 2012, Mr. Adams is required to sign a declaration of indemnity and to confirm his store pods investment instruction. That declaration of indemnity is littered with boilerplate too. No advice has been provided. You're doing this at your own risk. All that standard stuff that Carey thought it could rely upon. July 2012 is when the actual investment is executed. So there's a period of a few months there between the knowledge, the aggravating factors, and the execution of the transaction. And then shortly thereafter, in August 2012, Carey suspends further investments in Store First. In terms of the nature and the scale of the problem, the obvious point is that Carey has no control over CLP. It has no visibility either. It's relying on a contract and contractual mechanisms to control the behavior of CLP. Pipeline cases. As I said, Mr. Adams is an exemplar of a number of other pipeline cases. Carey, in this case, executes the transaction after it had sufficient knowledge to terminate its relationship with CLP. And in evidence, and it was John who was cross-examining at first instance, the CEO of Carey says, well, yeah, the reason we still went ahead with these pipeline transactions is because members like Mr. Adams were required to execute the declaration of indemnity, and in that they confirmed that they hadn't received advice. It's obviously preposterous, but that was the line that was taken by Carey. In terms of the magnitude of the problem and the short period of time in terms of volume, Carey had about 580 clients who had invested in store pods. That's a significant amount. Most of them, as in a huge substantial proportion of them, had been introduced by CLP. All of those investments in store pods in Blackburn had been made over about a 6-month period. In terms of financial ramifications, that represented about 10% of the assets held in Carey's SIPP, so a huge proportion. 20% of Carey's income in 2011 and about 30% of its income in 2012. And taking a step back, as the Court of Appeal did, and Lady Justice Andrews emphasized this, it would be unrealistic to suggest that CLP's activities did not lead to those investments. So in terms of the statutory claims, some basics which will probably be familiar to most, if not everyone, on this webinar. We've got Section 19 of FSMA, the general prohibition. Thou shalt not carry out regulated activities in the United Kingdom unless you're authorized or exempted. CLP was neither of those things. Section 22, What is a regulated activity? Well, for our purposes and for the purposes of this case, it's activity of a specified kind carried on by way of business and which relates to an investment of a specified kind. Specified means specified in the Regulated Activities Order, the RAO, made by the Treasury. Section 23 are criminal consequences because breach of the general prohibition can give rise to criminal liability. Sections 26 to 30 deal with civil consequences and civil liability. Section 26 deals with enforceability, stroke unenforceability in a two-party situation. That's not our case. Section 27 deals with enforceability in a three-party situation, which is our case. I should say, though, that the learning, or a lot of the learning in this appeal, will be relevant to a Section 26 claim as well. In terms of what you need to establish to get home under Section 27, well, there's two threshold conditions. The first is that you have to have an agreement made by an authorized person in the course of carrying on a regulated activity, not in contravention of the general prohibition. So in that case, that's the SIPP, and that's carry facing. Not contentious, I should say, in this case, one being established. Two was the contentious bit. So this is the third party condition. In consequence of something said or done by a third party in the course of a regulated activity carried on by a third party or by that third party in contravention of the general prohibition. And in terms of the civil consequences that flow, well, if that's established, subject to the statutory defense in Section 28, the agreement is unenforceable or prima facie unenforceable. The investor is entitled to statutory restitution, and it's also entitled to compensation. And bearing in mind the numbers that I've already identified in terms of Carey and its business through CLP, one can appreciate the potential financial consequences that might flow as a result of the Court of Appeal's decision. So the statutory claim is intimately connected with the RAO because to get home, Mr. Adams needed to establish that CLP had engaged in regulated activities. The regulated activities that were relevant for our purposes, we've got under Article 25 of the RAO, we've got arranging deals and investments. There were a number of exclusions to that. So Articles 26, 27, and 33 for our purposes. Article 26 is the important exclusion, and I'll go on to consider that in a few slides' time. Establishing, operating, or winding up a personal pension scheme under Article 52. Now that's relevant not because it's CLP facing, that's relevant because it's Carey facing. And again, it was common ground that Carey was carrying on this regulated activity. So that's number one of the two threshold conditions, and that's how that was established. And in terms of CLP, advising on investments was the second argument that was run. Article 53 of the RAO is the relevant article for that. So there were two regulated activities that were pursued that were CLP facing. It was arranging deals and investments and advising on investments. And in terms of regulated investments, so the specified investments, which is obviously one of the two things that needs to be established to establish a regulated activity, rights under a pension scheme. And again, this was common ground or a regulated investment for the purposes of the appeal. There are a number of definitions in Article 3, which are important. In our case, those definitions are buying, selling, and security. So both of the ways in for Mr. Adams, whether you look at arrangements or you look at advising, they need to relate to security or a relevant investment. An investment in store pods in Blackburn, it doesn't really matter whether it was Blackburn or not, an investment in store pods is not a security, and nor is it a relevant investment. And that was common ground. It was equally common ground that Mr. Adams' rights under the PPP and the SIPP were a security. because they satisfied the definition of personal pension scheme. Now, one of the arguments that was run by Mr. Adams, supported by the FCA, and I should say supported by FCA guidance, was even if the store pod itself is not regulated per se, taking cash within a SIPP and buying an investment in an unregulated investment, such as store pods, becomes a regulated activity because you've converted rights under your pension scheme. The Court of Appeal didn't agree with that argument and it rejected it. And I should say there was support for our argument in a number of cases. So I've mentioned them, all of the cases. I just didn't have space on my slides. All of the cases are referred to in the Court of Appeals decision, so you can pull off the citations quite easily. But Avocade, there was support for that in Avocade. Now, Avocade was decided shortly after judgment was handed down at first instance in Adams. Burns and the Financial Conduct Authority, Tenet Connect, which is a important decision of Mr. Justice Ousley's, and PERG 12.3 itself supported that argument, this conversion argument. So those authorities and that guidance will now need to be reconsidered in the light of the Court of Appeal's rejection. The reasons for its rejection were that they were of the view that Mr. Adams's rights under the SIPP weren't rights under contract. So it fell out of the statutory scheme, but they were rights under a trust or trusts. And so Mr. Adams did not convert, dispose of, or sell his rights merely by altering his investment. Now, the consequence of that is that advice on a SIPP exchanging assets, neither of which is a regulated investment, is not a regulated activity. So in this case, cash to store pods held within a SIPP does not come in the regulated perimeter. And that's a potential black hole. And it's something that could lead to potential issues in terms of a black hole, in terms of liability and redress. But it wasn't the end of the story, because there had been regulated advice, although His Honor Judge Dighton in his wisdom didn't think so at first instance. It was pretty patent to all and sundry, including importantly the Court of Appeal, that there had been regulated advice by CLP on in two respects. So those two respects were the sale of the PPP Protects Life and the establishment and or buying of the SIPP. And there's some interesting consideration in the Court of Appeal's judgment as to the meaning of advice. The two key cases up until this point are Walker and Rubenstein, Rubenstein being a decision of His Honor Judge Havelock Allen QC. It went up to the Court of Appeal, although the appeal was allowed on that case. It didn't touch or concern his learning on advice. The quote there is from Walker. It's from Mr. Justice Henderson. It's a very useful, short summary of the difference or distinction between information and advice. So anything in the element of comparison or evaluation or persuasion is likely to cross that dividing line. Perhaps one of the most interesting features of the recent Court of Appeal judgment is this concept of braided stream of advice. Now, the Court of Appeal didn't develop this concept, and that's not intending to be disrespectful to them, because there were soundings, and in fact, that term was used by Mr. Justice Ousley in Tenet Connect, and it makes good sense. So what they mean by a braided stream of advice is that where the advice on an unregulated investment, in this case store pods, justifies advice on regulated investments, in this case selling the PPP and establishing, buying the SIPP, it becomes part of the regulated advice. And that makes good sense because they're so connected or interconnected that it would be artificial to separate them. And that's exactly what the Court of Appeal decided, and you can see that in the 2 pages of Lady Justice Andrews' judgment. So at paragraph 68, Mr. Justice Newey says, advice on an unregulated investment is sometimes capable of involving advice on a specified one within the scope of Article 53, and so of being regulated activity. Now, it will be where it's so interconnected. And the consequence of that is that, as I've said, although the store pods itself were unregulated and any advice relating to that falls out of the perimeter, the advice on the PPP sale and the advice on the SIPP were regulated, and they couldn't be severed from the advice relating to the store pods, and therefore the whole thing became regulated and fell within the perimeter. So that was good news for Mr. Adams in terms of his advice claim. In terms of the arrangements aspect of the claim, I've set out the statutory definition there under Article 25. It can immediately be seen that it's an extremely wide definition. Importantly, it's cut down by another number of statutory exclusions. As I said earlier, Article 26 is the one that we're interested in. And that says, and it's effectively a causal requirement, arrangements which do not or would not bring about the transaction to which the arrangements relate. So it's a causal requirement. There was quite a bit of debate in the court below and in the Court of Appeal on what that causal requirement was, because the legislature, in its wisdom, hasn't told us. So on the one hand, Mr. Adams was arguing, at least at first instance, for causation. The other side, Carey was arguing for direct and substantial causal connection. Now that's a higher standard. That found favor at first instance, and in the Court of Appeal, came up with its own test, which is neither of those two things, and it's somewhere in the middle. So it's causal potency, which effectively means arrangements which play a role of significance. So not quite but for, but not as stringent as direct and substantial causal connection. And so in terms of the arrangements, the threshold question for the Court of Appeal was, did CLP make arrangements for Mr. Adams to transfer his PPP and put the proceeds into the SIPP, which were such as to bring about those transactions? And the answer, again, good news for Mr. Adams, was yes. And there were three reasons. There were a number of arrangements, I should say, that were relied upon, or alleged arrangements that were relied upon by Mr. Adams, but three found favor with the Court of Appeal. The first was CLP procured a letter of authority, which Mr. Adams was required to sign, which authorized Carey to liaise with CLP. The second, and almost astonishingly, is that CLP undertook money laundering investigations on behalf of Carey. And the third was completion of the SIPP application form. And the Court of Appeal considered that those acts in combination were significantly instrumental to satisfy the test of causal potency, despite the fact that they were effectively administrative in nature. So where we're left with in terms of arrangements is it's a wide approach to the meaning of arrangements. That's consistent with the High Court's approach in Avocade, which tried to distinguish our case at first instance because it was trying to get around it. But that's good news for investors. So a wide approach. It's also consistent with the Supreme Court's approach to the meaning of arrangements under Section 235 of FSMA, which is the definition of collective investment scheme. So we saw that in Asset Land in the Supreme Court. So where we were left with the statutory claim is that the SIPP was entered into, and the Court of Appeal found favor with Mr. Adams's argument as a result of regulated activities that were carried out by CLP in breach of the general prohibition. The consequence of that is that the SIPP is prima facie unenforceable, subject to the statutory defense. And I conclude the section just with paragraph 131 of the Court of Appeal's judgment. And the short point there is a point that we had tried to take is that the regulated landscape was such that you shouldn't deal full stop with unregulated introducers. Lord Justice Newey and the rest of the Court of Appeal disagreed. But the fundamental point is that the risk is thrown on the regulated entity, and contract will only take you so far in protecting yourself when you're a regulated entity dealing with an unregulated entity. So I'm going to pass back to John, who's going to go through the COBS claim.
Thank you very much, Jay. The alternative basis of claim under COBS may have, I suppose, slightly limited or a lesser role to play if these claims go forward, in that if a Section 27 claim is available, then there probably isn't, except in cases where it is thought that the statutory defence might be successfully deployed, it wouldn't be any point in deploying a COBS claim. The other area where this claim may prove relevant going forward, I suppose, are entail cases where the introducer was an authorised entity, so that Section 27 isn't engaged at all, but where that introducer, and I'm sure we've all had experience of this, has ended up being uninsured and unable to meet a claim. And the question then will be, well, can a claim be pursued against the SIPP provider? And the mere intervention of a regulated advisor as part of the process should not in itself be sufficient in and of itself to exclude a claim under COBS, if a claim under COBS is available. So I turn to look at that. The genesis of the argument arises from the decision in Ex parte Charlton, a case against Barclay Burke, which after a very long and protracted litigation history resulted in an award being upheld in Mr. Charlton's favour on template facts very similar to those that are exemplified in the Adams and Carey options case. The Financial Ombudsman Service recognised duties imposed on SIPP arrangers and providers, framed essentially around two provisions in PRIN, the Principles for Businesses. First, PRIN 2, which imposes an obligation on businesses to conduct their affairs with due care and skill, and then secondly on PRIN 6, which is a duty to treat customers fairly, the TCF duty. In the Charlton case, Mr. Charlton was persuaded by an unregulated introducer to transfer his personal pension plan, again of a relatively modest value, about £24,000, to Barclay Burke, so that he could invest in jatropha trees in Cambodia, being offered by a company called Sustainable Agro Energy. And as I have quipped previously, the only aspect of this transaction which was sustainable proved to be the aggro that poor old Mr. Charlton suffered thereafter. It emerged that the whole investment was a fraudulent scam, and Mr. Charlton, having committed his funds to it in September 2011, by February 2012, all of his money had disappeared. Barclay Burke accepted that they had not made any investigation as to whether the trees which were to be the subject of the investment had been planted, or if Sustainable Agro Energy had title to the property in which the investment was being made. The Ombudsman took account of a whole series of factors which led him to the conclusion that Barclay Burke, a SIPP provider, had certain due diligence duties to the pension owner. First of all, he observed that Sustainable Agro Energy could and easily have identified that this was a high-risk, speculative, non-standard investment, which in and of itself was a trigger to require sufficient due diligence. What amounts to sufficient, I suppose, is going to be fact sensitive. But it included, the Ombudsman said, consideration by Barclay Burke as to whether the sustainable agro investment was appropriate for a pension scheme at all. And I'll come back to that thought in a moment. It entailed investigating whether the investment was genuine and not a scam or linked to any type of fraudulent activity. Critically, it extended to verifying whether sustainable agro-energy's assets were real and secure, whether the investment was operating as the literature around it was claiming, and whether the investment was capable of being independently valued, both at the point of purchase and also subsequently, and I'll come back to that in a moment. All of that meant that Barclay Burke could and should have recognised that this was, if they'd done appropriate or sufficient due diligence, recognised that this particular investment was high risk, speculative, not secure, a scam, and not appropriate for them to accept it within the SIPP wrapper. Now, the move from the Ombudsman context into the litigation context entails this transition. PRIN provisions are not enforceable by private investors, so one has to look for a basis of claim outside those provisions, and the obvious candidate is COBS 211R, the rule which obliges authorised entities to act fairly, professionally, and at all times in the client's best interest. And the question then becomes, well, can one populate the COBS 211 duty with the sorts of due diligence obligations which were upheld by the Ombudsman as requirements for the purposes of the PRIN provisions. The first observation that can be made, I think, is that all SIPP providers, in my experience, accept that they have, as a minimum, an obligation to establish whether or not the proposed investment is, quote, SIPPable. In other words, whether it's one of those investments which, although able to be held within the SIPP wrapper, if taken in, may attract an unauthorised pension tax payment charge. If so, then it's not likely ever to be in the interests of the investor to go down that route. So that minimal level of due diligence is conceded as necessary. And of course, it then opens the door to considering, well, how much further should the due diligence go if COBS 211R is to be complied with. And the next observation, which logically follows, is that the structure of SIPPs, as Jay was explaining a moment ago, of course entails the assets being held by SIPP trustees. And inherent in the concept of holding an asset is that there must be some form of recognised legal title to it. And again, I'm sure we've all encountered some extremely esoteric described concepts, fractional interests in beneficial interests of leases being an example, where the question is immediately one which will scratch, of course, any property lawyer to scratch their head as to whether what's being offered entails a recognisable legal title which is capable of being held by trustees. The third or next obvious consideration is whether or not the asset is capable of being valued. There are, as I'm sure we all know, obligations on SIPP providers to provide annual valuations of the assets held within the SIPP. And if the nature of the asset is such that it is incapable of being reliably valued, then that again suggests it is simply not an appropriate asset to be held within a SIPP. If there are indicia of fraud, or that the whole venture is some form of investment scam, then again, that is not, I would suggest, asking very much of a SIPP provider to keep a weather eye out for that possibility and to decline investments where there is a real suspicion of fraud. Pensions, of course, provide not only, or intended to provide not only an income when vested for the purposes of a non-retirement, but also provide a potential death benefit fund in the event that the pensioner does not survive to an age when they can take their pension. Now that entails necessarily the concept that the asset is itself going to be realizable, because there's not much point providing death benefit via that kind of policy or that kind of arrangement if it is incapable of being readily realized. All of those types of consideration feed into a broad assessment, I suggest, as to whether or not the underlying investment is, inverted commas, appropriate for inclusion in the SIPP at all. I mentioned also the question of what I've described as burdens on a trustee, and this was also a feature of the Adams case. Having taken title to the leases of the store pods, those leases included obligations on the trustees to make payments, and it was a combination of that liability which ended up being inadequately serviced by sublettings or further uses of the store pods, and the costs inherent in the SIPP product itself, which resulted in the small cash reserve that had been set aside being completely depleted in any event. So if the nature of the investment, again, is one which is going to impose unserviceable costs as a burden on the trustees, one has to stand back and ask, well, is this an appropriate investment for inclusion in the SIPP wrapper at all? And then lastly, what is the provenance of the introduction of this particular type of product? Is the introducer carrying on a bona fide business, or are they operating outside the regulatory perimeter? It was well, Justice Newey who observed in Adams, for example, that it was most unlikely that 580 individuals woke up one morning and all decided to transfer their existing pensions into store pods in Blackburn. Inevitably, that was going to be the result of persuasion or advice, and it was known that CLP was not an authorised regulated entity. There's then the question also as to whether the introducer has itself been the subject of any FCA warning notice. It's the click of a button on the FCA website to undertake that investigation. So none of that really postulates any seriously difficult set of exercises for SIPP providers to undertake and carry out. Those sorts of duties and considerations are set out in a large number of FCA, FSA, FCA publications, and I've listed those on that slide, so I won't go through them. I just highlight in particular the formal guidance on this topic issued by the FCA in October 2013. Now, the question at the moment then is, well, what is the status in terms of civil litigation of the FOS endorsed duties? And although breaches of COBS 211R were alleged both at trial and on appeal, both courts concluded they were not sufficiently developed, in particular by the absence of expert evidence, and effectively neither court was prepared to venture into this territory. I smile somewhat wryly by the protestations of Carey that expert evidence was needed to address those issues, because my almost invariable experience is that regulated entities seek to persuade courts routinely not to instruct or allow the permission for expert evidence in this area, contending it's all a matter of law for the judge to determine as to the scope of the rules, or alternatively it's just a question of fact as to what other providers do or don't do, none of which it is suggested necessarily gives an answer to a legal question. But for forensic reasons, it suited very obviously to contend in this case that expert evidence was needed. What I think can be said going forward is, in cases where that type of COBS claim is going to be deployed and there's evidence to support the lack of due diligence in the areas I've outlined, one can point to the publications by the regulator in the slide mentioned above. Secondly, there are these skeleton arguments, which I think are publicly available, deployed by the Financial Conduct Authority at both first instance and on appeal, which identify the regulator's insistence that due diligence is appropriate, and the FOSS type of due diligence recognised in Charlton is what's required. There is, of course, then the FOSS Charlton decision itself, Mr. Justice Jacobs endorsing that approach, certainly in the context of PRIN. And as I've said, it's difficult to see why that doesn't translate across into COBS 211. And then there is finally the emphasis, both in Charlton and in Adams, on the need for consumer protection and to protect consumers from their own folly, which again strongly suggests that COBS 211R can and should be populated with those sorts of due diligence obligations. I'll pass back now, I think, to Jay.
I'm going to deal with my final few slides quite quickly. The statutory defence under Section 28, which was ultimately unsuccessful for Carey. Now, Section 28(3) gives the court a discretion to allow an agreement which is prima facie unenforceable to be enforced where it's satisfied that it's just and equitable to do so. In a three-party situation, so two-party situation, Section 26, three-party situation, Section 27, the court's mandated to consider a specific issue. That issue is whether the provider, so in this case Carey, knew that the third party, in this case CLP, was acting in the carrying out of the regulated activity in contravention of the general prohibition. Now, Heldon and Strathmore is an important case. It's well known. Mr. Justice Newey, as he then was the judge at first instance. It went up to the Court of Appeal, but the best learning in that case is the first instance judgment. If knowledge is satisfied, so if that requirement's satisfied, well, that'll be a weighty factor against the regulated entity in terms of not exercising the discretion to allow the agreement to be enforced. But if that factor isn't present, that doesn't necessarily mean that the court will exercise its discretion, because it needs to consider all relevant circumstances. So in this case, the Court of Appeal concluded there was a debate whether it was actual or constructive knowledge. It concluded that actual knowledge was required. I make the point that that's a potentially surprising outcome. It's based on a narrow approach to the meaning of new in Section 28(6). That's not to say constructive knowledge isn't important, because it is important, as it was in our case, to the other factors that the court has to consider. In this case, the Court of Appeal, I would say generously, found that Carey did not have actual knowledge. Now, the first few slides that I was talking to, setting out the chronology, I think that's a potentially remarkable outcome, and it was a very kind outcome. But it was no doubt influenced by the fact that the Court of Appeal was going to consider all other relevant factors and still find against Carey. I would say that it did have actual knowledge, but it doesn't really matter for our purposes, because the court decided not to exercise its discretion. Now, it reached that conclusion for the following reasons. This will be welcome news to those who advise on the claimant side. The key aim of FSMA is consumer protection. Section 27 is specifically designed to throw the risks of accepting introductions from unregulated entities onto the regulated entities. And it would be a surprising outcome if the court liberally exercised its discretion under Section 28 in those circumstances. I took you to a slide about the huge volume of introductions through CLP and the fact that most invested in store pods, and the court basically concluded that there were sufficient alarm bells in play. And John stole my thunder in terms of the slide, or in terms of the statement from Lord Justice Newey, but the statement's there. In effect, people didn't wake up one morning and decide to invest in store pods in Blackburn, and certainly not 580 of them. The final two factors which weighed against Carey, well, again, coming back to the chronology, it had knowledge in May 2012 about higher commission, payment of inducements, and the FSA warning notice. It actually terminated its relationship with CLP, but it, for whatever reason, no doubt commercial reasons, decided to execute the pipeline transactions. And it took no steps in the intervening 2 months before the actual investment instruction was executed to act on the material and on its knowledge, and it didn't inform investors like Mr. Adams.
So just to turn briefly to the other line of defence, and that relied, as Jay outlined earlier, on the raft of disclaimers which Mr. Adams has signed up to, and which is a common feature of these sorts of transactions. Statements affirming that the pension plan holder has not been advised by the SIPP operator, is taking responsibility for their own investment decisions, not relying on the SIPP operator in any way, and indeed going so far as to suggest that an indemnity is being provided if losses eventuate. I've always been of the view that those disclaimers are ineffective, and there are, I think, three aspects to that conclusion. The first is that obviously the disclaimer cannot be effective to defeat a Section 27 claim, because if it was sufficient merely to point to the fact that an unauthorised introducer had instructed a particular transaction which had resulted in the pensioner instructing the SIPP provider to put it into effect, then Section 27 would be deprived of all and any force. The second observation is the need to safeguard consumers from their own folly, which was very much in part of the thinking behind not allowing the statutory defence to succeed in Adams. That must apply with equal force in the context of COB duties and rules. And indeed, logically, if the COB's 2.1.1 rule duties of due diligence are recognised, then they become a requirement of statute. And COB's 2.1.2r, of course, contains a complete prohibition on contracting out of obligations owed under the regulatory system. And for all of those reasons, it's impossible, therefore, I think, to see how that type of disclaimer could ever be effective. So in brief, that's all I say on that topic. I'll pass back to Jay again to conclude.
Just some concluding remarks. What have we learned from this appeal? Well, the first thing we've learned, and it's not on the slide, is you probably shouldn't invest in store pods in Blackburn. Mr. Adams' store pods are worth a fraction of what he paid for them. So it was a very bad investment, and hence the claim and hence the appeal. It's a significant case for a number of reasons. There are a number of existing cases, as I've said, which are going to be directly affected by the outcome. Primacy of consumer protection is an important point and an important theme which emerges from the judgment. More significantly, outside of the SIPP sphere, but also within the SIPP sphere, there's wider learning on advice and arrangements, and that'll be important more generally. Particularly the braided stream of advice, which will capture unregulated activities where they're closely connected or interconnected with regulated advice. I've mentioned the wide approach to arrangements, and obviously that will have wide applicability outside of the SIPP sphere. Dare I say there might even be some people watching this webinar who have written articles, who work for firms, who have written articles which I've seen, which suggest, well, because the Court of Appeal rejected the COB's appeal, His Honour Judge Deit's judgment is gold dust and on the COB's aspect and is unimpugnable. Well, that argument still is very much alive, and it's left to be argued on another day. And I think if it's argued more fully on a properly pleaded basis, I think a different court on a different day might reach a very different conclusion in the light of our appeal for the reasons that John gave. And finally, contractual controls will only assist so much, especially where unregulated introducers are involved. So that finishes our talk. Sorry, we've overrun by 4 minutes or so. We started a few minutes late to allow people to join. We're happy to answer questions through the chat function to the extent that we can. If you have any other questions and think about them later, or would prefer to email us your questions, please feel free to do so and we'll endeavor to respond. Thank you for joining, I should say, and good morning. I can't see any questions so far. John?
Thanks very much, both of you. That was really useful. Do I take it, Jay and John, that you think that the black hole potentially could be covered by COBS pending further developments, probably above the Court of Appeal?
By black hole, you mean the black hole of taking a unregulated product, say cash, and investing it, this is within a SIPP, into another unregulated product, such as straw pods and Blackburn?
Yeah. So the scenario is you've already got a SIPP which has been established, and you're, in effect, as I understand it, as you've articulated, the Court of Appeal have said that the position is that in that scenario you don't have your statutory claim, but a COBS claim would still potentially work in that scenario, as I understand it.
Yes, I mean it's runnable. It looks like John has left the chat, and obviously he was dealing with the COBS bit, but yes, it's arguable. What I would say in terms of the COBS claim is it's pretty clear from the judgment that the Court of Appeal, despite our protestations and despite the FCA saying, well, that was probably the most significant aspect of the appeal, and they would really welcome some judicial guidance on the issue. They took a pretty narrow approach and just said, well, a number of the points that are being pursued on appeal weren't actually ventilated at first instance and hadn't been properly pleaded. As John said, if you can get your hands on the FCA skeleton, there's some pretty good material in there. And what they identified were a number of red flags in their skeleton. We were trying to argue that all of those red flags were in play in this case. And I think, as I said, on another day in front of a different judge, more fully argued, that COBS claim might get a lot more traction, and that might be a solution to the black hole problem. I'm not saying it's an easy argument, but certainly His Honour Judge died, and in the first instance judgment, his reasoning is really poor.
Good, thanks. It looks like we've got a couple of questions in on the chat function now.
So first questions, any rumbling on an appeal to the Supreme Court? Well, its judgment was handed down on the 1st of April. It's the 21st of April. There's no news at this stage. They applied, and this is public knowledge, they applied for permission to the Court of Appeal, as they had to do if they wanted to appeal to the Supreme Court. That permission was refused. So all I can say is I have no news on that subject, and they're about to run out of time to make the application. What I would also say, and I don't want to get ahead of myself, is and I would say this is the Court of Appeal's judgment is unimpugnable. To a large extent. I don't think the Supreme Court's going to be overly interested. I don't think, sorry, I've just received a few calls from my receptionist. I don't think the Court of Appeal is going to be very interested in an exercise of judicial discretion, which is effectively what the Section 28 bit is. In terms of the Section 27 aspect, it's pretty clear, tolerably clear, that there was advice given by CLP. The braided stream of advice stuff is, we would say, unimpugnable, and the arrangements commentary is also, we would say, unimpugnable. So at least on our side, we think the Supreme Court won't be very interested in reconsidering this issue. I can see that David Green's asked a question. Were transfers out of occupational pension scheme, do the trustees of that have any obligations to those seeking to transfer SIPP with investments of this nature? So as I understand that question, do the trustees of the existing occupational pension scheme have any obligations to those seeking to transfer to a SIPP with investments of this nature? That's a very different issue. My high level view is I think it would be a surprising outcome if they did owe duties in terms of more extensive duties to consider the appropriateness. I'm using that term appropriateness quite neutrally rather than suitability. Their duties to me, at least on a high level, would be ensuring that the transfer is effected in accordance with the client's instructions. And I'd be surprised if they had any duties that went beyond that. Just looking to see if there's any more questions. I think that's covered the questions so far. As I said, if there are other questions, they can be fed through to us by email, and we'll do our best to answer your questions.
Thanks, Jay. Thanks, John. That was both very useful. Enjoy the rest of your day.
Okay, well, thank you everyone for joining, and thank you to those who have joined and already left.